No laws are perfect.
The wrong is still a wrong.
Now that's what you call a trespass or an incompetent law.
What was taken away was powers they never had.
Hello everyone, welcome back to another episode of Beyond the Headlines, your one-stop for all the stories that made the headlines and more. I'm Hasbin Hassan, and this week we're still on the landmark decision delivered by the federal court that has declared just last Friday 16 out of 18 provisions under the Kelantan Syariah criminal enactment unconstitutional. Now, if you've been following us, we had both Nick Elin Zurina and her daughter, Tengku Yasmin Nastasha, in a Beyond the Headlines exclusive over the weekend. And today, we're going to get more acquainted with the issue of an overlap between laws in the federal list and state Sharia laws and explore the notion of ultra vires, the point of contention in Nick Ellen's constitutional challenge. And for that, I have joining me in the studio today two very learned guests, constitutional lawyers, Emeritus Professor Shad Saleem Faruqi, the chairholder of the Tunku Abdul Rahman Foundation, and Surendra Ananth, who is also the counsel representing Nick Ellen and Tengku Yasmin in their recent constitutional challenge. Gentlemen, welcome to Beyond the Headlines.
Thank you very much, Hasbin. Thank you.
Now, perhaps I can start with you first, Professor Shad, to get us more learned on constitutional literacy. I think that I speak for a lot of people. Perhaps not many people out there are aware of this. To be more literate about the separation or the divisions between federal and state jurisdiction when it comes to Islamic legal affairs. Perhaps can you start off by explaining to us?
Thank you so much, Hasbin. You're entirely correct. Constitutional literacy is very low. Constitutional patriotism is even lower. And let me just point out to you some of the constitutional fundamentals that our constitution makers adopted in 1957. One is this, that we chose a supreme constitution. The implication of that is that Parliament is not supreme and state assemblies are not supreme. Their powers and functions are delineated by our supreme constitution. For example, on lawmaking matters, legislative matters, there is a federal list containing 27 topics. For the states, there is a state list in Schedule 9 containing 13 topics. And there is a concurrent list containing 14 topics. Now, along with the Supreme Constitution, we have Islam that has been given a very exalted position in Article 3, Clause 1. Islam is the religion of the Federation, but all other religions may be practiced in peace and harmony. However, Article 3 also contains an Article 3, Clause 4, which says nothing in this article derogates from any other provision of the Constitution. In other words, though Islam has this very exalted position, the provision about Islam is not meant to displace or to cancel out any other institution or law or procedure in our Constitution. Sharia courts exist under the Constitution. Muslims are compulsorily subject to the Sharia in two broad areas, Hasbin. One is there are about 24 topics of personal and family law on which Muslims are compulsorily subject to the Sharia. Second area is that there are some offenses against the precepts of Islam which the state assemblies can create and punish. The words precepts of Islam have nowhere been defined, but a string of cases from the superior courts have said that precepts of Islam refer to aqidah, akhlaq and adab. Now the important thing to note is this. Besides the offenses against the precepts of Islam, all other crimes, Islamic crimes, are not in state hands. So murder is, of course, an Islamic crime. Theft, robbery, rape, incest, homosexuality, they are not in the state list. Only offences against the precepts of Islam, a judge described them as religious offences. They are in the state list. This is generally not understood. Many people say the entire area of the Sharia is in state hands. That's not correct. Just now we were discussing the Hajj, the holy Hajj, the sacred Hajj actually is a matter of federal power.
Right.
Islamic banking is a matter of federal power. The punishments that can be imposed by the Sharia courts must be determined by federal law. And there is the Sharia Courts Criminal Jurisdiction Act 1965, which says the punishment can be 365, 3 years jail,
Right.
6 strokes of the rotan, 5,000 ringgit fine. And finally, if any of the legislatures, any of the state legislatures violate the federal list, or the federal parliament violates the state list, there is the power of judicial review. The courts have the power to invalidate the law. But they don't have to invalidate the entire law. They can invalidate the provision.
Right.
We call it severability. They sever the good from the bad. And I think that's what happened in this case. Not the entire Kelantan enactment, but
Right.
those parts that were a trespass on the federal list were severed.
Right.
Thank you.
And so, right away, we can establish that what this means essentially is that, number one, we have to understand that the Constitution is the highest law of the land, and that has to be respected, right? Anything that overlaps or oversteps that would be unconstitutional. In the case that has been proven through the challenge by Nick Allen, right? So, can we now go back to the whole point of the challenge put forward by Allen was a challenge of competency. So it is about the competency of lawmakers, and in this case, the lawmakers in the Legislative Assembly of Kelantan. So what does it mean to be competent as lawmakers? Why is it that we don't have competent lawmakers, and that the challenge has been proven correct, as in they're unconstitutional? We found provisions unconstitutional.
All right. So I think, like Prof. Shad said earlier, there's a division in what you call a federal list and also a state list. So the federal list outlines certain items on which Parliament can make law on. These laws are called federal laws. Then we have a state list, which has certain items on which the state legislative assemblies can make laws on. And you have various state legislative assemblies. Then you also have a concurrent list, where both Parliament and state can make laws on that matters. And you then have a supplementary list for Sabah and Sarawak because of their special status.
Right.
So when one talks about competency, Parliament can only make law on what is in the federal list and concurrent list. The state assemblies can only make law on what is in the state list and the concurrent list. Yeah. And then for Sabah, Sarawak, you have the additional list for them. So if, let's say, Parliament were to make law on something that's in the state list, it's not found in the federal list. For example, on rivers, or on land, for example, which is actually in the state list, without state permission. Now, that's what you call a trespass or an incompetent law, because Parliament did not have the power to make that law.
Right.
So people often get confused between an incompetent law or a competency challenge, like you put it, and a unconstitutional or an inconsistency challenge. So, for example, let's say Parliament makes a law which is within the federal list, and you have various laws for that. But even though these laws were made within that list, it's competently done, but it nevertheless violates certain fundamental rights. For example, right to life, free speech. So let's take the Peaceful Assembly Act, for example. We have a Peaceful Assembly Act. No doubt Parliament can make that law. It has the power. But one might argue that certain provisions in that law is a violation of our freedom to assemble, which is a constitutional right under Article 10. So that's a fundamental rights or a consistency challenge. So the two has to be clearly demarcated. What happened in this case, in Nick Allen's case, and what you were referring to, is a very special scenario where the lawmakers have made a law that they didn't have power to make. And sometimes it is not as clear-cut. Sometimes you can argue that this matter could fall under this item in the federal list, can also fall under this matter in the state list. It's not very clear-cut. It's hard to demarcate. And that's why you don't see many challenges of this nature. In fact, I think I can count in my two hands about how many challenges we have had of this sort of nature. It's very rare, and which is why it can only be done in the highest court of the land, which is the federal court.
Right. Isn't that concerning, though, that we are seeing this overlap? And as you pointed out, if we look further, there could be, because there's not a lot of clarity in terms of the jurisdiction where we draw the lines between the state and, federal levels of law enactment. So shouldn't be this concerning? I mean, I'm listening to what you have to say. It's quite concerning to me, actually, because there is quite little clarity on this.
Yep.
Yeah.
I think Prof. Shad can add as well. But basically, this is, I wouldn't say it's concerning. It might be concerning in certain circumstances, but it happens in all federalist systems.
Yes.
Canada and India, they also have federalist systems. And in fact, in those jurisdictions, maybe they've been around for a longer time, you have way more cases on where the UFC overlap. So for example, a very easy example is gambling is in the federal list. Local authorities is in the state list. So when you talk about gambling, on one hand, you have the license to conduct a gambling den, for example.
Okay.
That comes from the Minister of Finance. But it's not enough. You still need to get a permit or approval from the local authority on your premises, your safety aspects. That falls within the state list. But the two can get convoluted at times. So I think recently you had the Sabah government announce a few years ago that they're going to ban gambling activities. Can they do that? So there you go. That it's not that clear cut. And these sort of issues, to be honest, in other jurisdictions have happened so many times. So in a way, well, yes, it can be concerning at times, but we need to understand that these things happen everywhere. No laws are perfect, and that's why we have the courts. They are there to interpret the law.
To rectify
Can
the
I just
situation.
add to
Sure,
that?
please.
There are hundreds of laws, and obviously they overlap in some cases. That's why there is an Article 75 which says if on a particular matter there is a clash between a federal law and a state law, the federal law prevails.
Right.
So the Constitution does provide or try to provide some solution that, I'm generalizing of course, but in general, if there is a clash between a federal law and a state law, even if it's on a matter in the concurrent list, federal law will prevail.
Right. Okay. So now more on the challenge brought by Nick Ellen, the 16 provisions, right, that have been found unconstitutional. So probably I'll first introduce the two that have remained status quo, because there have been 18 that were challenged. So sections 13(1)(3) and 30(3)(0) are selling or giving away a child to non-Muslim or morally reprehensible Muslim, and section 30, words capable of breaking peace. These two remain status quo, that were part of the 18 provisions challenge. Can you shed more light on that, Surendra?
Yeah, so essentially what the federal court decided, and it merely followed its earlier decision called EP22, quite simply this, because you have criminal law in the federal list, which the court did not define. And criminal law, it's a hard concept to define. And then you have, like what Prof was mentioning earlier, I think precepts of Islam in the state list, which is very wide and covers a lot of matters. But then you have that preclusion clause. If it falls under federal jurisdiction, state cannot make the law, even if it's within precepts of Islam.
Right.
So when you referred to the two sections earlier, what the court found in essence was that where it is a pure religious offense, and that means an offense that is against the precepts of Islam and only concerns Muslims, then the state can enact the offense, because that is not a law which would fall within the federal jurisdiction of criminal law. So for example, just going beyond the two sections, not fasting in a public place, that is against the precepts of Islam and only concerns Muslims. Zina, for example, is against the precepts of Islam and only concerns Muslims. So that's within state Islamic law jurisdiction. There's a lot more examples I can give. Gambling, consumption of alcohol, all those are purely religious offenses. So in this case, the court found that sections 13 and 30, which you mentioned earlier, were purely religious offenses, and therefore the state, Kelantan state, was entitled to make them.
Right. But the thing is, a lot of the narrative that is circulating opposing this decision is saying that I would say I probably describe them as being knee-jerk reactions, right? It's saying that, does this mean then that these crimes, especially in the perhaps the ones that you didn't mention, things like sodomy, bestiality or intercourse with a non-human, necrophilia, sexual intercourse with a corpse, that's section 16 of the Kelantan criminal enactment. So does this mean then, some people are saying that these crimes cease to be crimes in Kelantan when it doesn't quite fall under the provisioning of Islamic laws per se? What do you have to say about that? I mean, I understand from your earlier explanation that it is already under the penal code, these crimes, right? And especially if it's purely in Islamic illegal wrongdoing, then that will be under the provision of Sharia laws. But how do we quash this narrative then? Because I would think that this is trying to mislead people. And so what would you say to, quashing this argument?
Can I try?
Yeah, please.
Partly it is lack of legal knowledge, lack of constitutional literacy, but there is also a malicious attempt to discredit the courts and the petitioner. To say that because the courts have said Kelantan cannot punish these offences, therefore the court is legitimizing these actions, saying these actions can now be committed by everyone. That is malicious. The court is not saying that at all. What the court is saying is this is already an offence under federal law. The jurisdiction is that of the federal parliament. The venue must be the civil courts, not the Sharia courts. And may I just add, anyone who says that declaring the Kelantan law, let us say on sodomy, now means sodomy is being permitted by the court. That's very funny, because under section 377A of the penal code, it's 20 years jail and whipping.
Right.
Whereas under the state law, actually, it is maximum 365.
Right.
So the offence is very much in place and is subject to prosecution. The wrong is still a wrong. It has not been legitimized.
Right.
But the whole issue is who had the power to pass this law and what is the venue in which the offence must be prosecuted.
And if I could just add to what Prof said, I think another thing that these commenters were saying, and then I saw a video on TikTok, they were saying, okay, so now Parliament has the power to make laws on these areas within their jurisdiction.
Right.
But what if they don't make the law? Or what if they make it and then it only applies to Muslims? Would that law not be discriminatory and liable to be struck down?
Right, yes.
But that scenario won't really exist, because like I said earlier, I think in this judgment, the federal court made it quite clear, if it is a religious offence that only affects Muslims, then that's within state jurisdiction. So this commenter, for example, gave certain instances. First, she said zina. No one challenged zina, because it is a purely religious offence within Islamic law. Then she gave the example of gambling. Now, what many people don't know is that we dropped the challenge on gambling, one aspect of gambling, which is the act of gambling.
Okay.
Licensing gambling activities or gambling, that's within federal jurisdiction. But the act of gambling is an offence that only applies to Muslims and Muslims alone, which is why we conceded that is a valid Islamic law. And then she gave the example of consumption of alcohol. Again, no one challenged the offence of consumption of alcohol, because that is a purely religious offence. So I think a lot of people are looking at or pinpointing these certain offences because they are somewhat flashy and big, but then they don't examine the challenge and what happened in court, that Nick Allen actually focused only on the provisions which are already provided under federal law and quite clearly fall within the federal list, and she was quite happy and fair in dropping the challenges for certain provisions which, okay, this is fairly within state purview, it's purely religious, so let the state make it. So in that sense, I think it's being overhyped and misstated a lot as to what actually happened in court.
Okay.
See, if on the same offence you have two separate systems of laws and two separate venues, that's going to create problems about, first of all, equality before the law.
Right.
Muslims will be prosecuted in the Sharia courts for a lesser offence, for the same offence. the non-Muslim will be prosecuted in a civil court for a much greater penalty.
Mm-hmm.
There may even be problems of double criminality, which is forbidden by Article 7, Clause 2, double jeopardy. A person may have been prosecuted by using a different word, a different description, but the essential facts are the same. Then he gets prosecuted in the.
Is this the
other
same
section.
as being prosecuted for the same crime twice?
Yes.
Along
Yes,
those lines,
yes,
right? Double jeopardy.
The law says if someone has been acquitted or convicted, then he cannot be prosecuted. He cannot be tried again and again.
Right,
Yes.
right. So I want to just go back to the how civil law penalties and punishments under civil law is actually harsher than some of the ones under Sharia law. So perhaps, some of these dissenting opinions, people with, the knee-jerk reactions, is it possible that they actually want more lenient laws in place for the said criminal offences, whether Islamic or not? Do you think that's probably one of the reasons why they're opposing this, for more lenient laws, or is there something else to it?
I think the intention in 1965, when the Sharia Courts Criminal Jurisdiction Act was passed, the intention was to give to the Sharia courts power over minor offences.
Okay.
So drinking, not fasting, not saying your prayer, khalwat, zina. That's why this ceiling was placed, 3 years jail, 6 strokes of the rotan, 5,000 ringgit fine. This scale of punishments is actually within the power of the magistrates' courts. So the Sharia courts in criminal matters have the power of magistrates' courts. Now, this was not meant to put the Sharia courts down. I think the purpose was Sharia courts will basically be prosecuting religious offences of a minor type. Ordinary offences, murder, rape, theft, robbery, treason, would all be prosecuted by the civil court. That's why the penalties were larger. But there is no bar to amending the 1965 Sharia Courts Criminal Jurisdiction Act to enhance the penalties if that is felt necessary.
Yeah.
Do
and
you
I
think-
the intentions, like you said, I think Prof did answer as well that it could be just ignorance or it could be just malice. They know, but they're doing it, so saying it for their own political reasons.
Okay. Now, more on what other people have had to say about this issue, and I'm alluding to politicians and ministers. So the Foreign Minister, Datuk Sri Muhammad Hassan, he's commented on the decision, the federal court's decision, as being purely a technical issue. And I quote him saying, "Personally, in my opinion, the issue is solely about the Kelantan government drafting laws that are overlapping with the constitution. And this is obviously not allowed. In the constitution, this issue is more about technicalities. It has nothing to do with the federal court undermining the powers of Sharia courts or the Sharia courts or Islam." End of quote. So can I get you to please elaborate more on that? What does he actually mean by technicality? Why is this just purely a technicality?
Yeah, I think he's right on the most part of it, but perhaps the use of the word technical might not be the best word to use in the circumstances.
Jurisdictional.
Yeah, it's a jurisdictional issue. So
Right.
it's not a technical issue. It is an important issue because it goes to the issue of who has the power to make these laws. And that's important because if the wrong person makes the law and then applies it to people and they get convicted, a lot of trouble and a lot of prejudice can result. So, but he is right in the sense that these offences still exist under your federal laws. People still can get charged and convicted under these offences. And he's also right in saying that the court did not touch on the position of Islam or the Sharia court. Article 3, like Prof mentioned, that's still there. The power of the states to make Islamic law in the state list, that is still there. All the court did was to clarify the extent of that power. The Sharia court's jurisdiction, which Prof also mentioned earlier, the 356, the maximum, that's still there. No one mentioned the Sharia courts or touched on the Sharia courts. In fact, if Parliament now wants to increase the punishment cap, they can still do it.
Right.
Yes.
This is purely about, is it Parliament or the state that should make the law? That's really it.
Okay.
Can I also add to that? I think the learned speaker here was quite correct in pointing out, and I agree with what you said, that the position of Islam as the religion of the Federation is in no way affected by this Nikhilin decision.
Right.
The position of the Sharia courts is not affected. You know, the word Islam is mentioned in the Constitution about 28 times.
Yeah.
And that stays. All the powers that were given to the Sharia courts in the Constitution still stay. None of those powers were taken away. What was taken away was powers they never had, which they were exercising without jurisdiction.
Okay.
And if they exercise it without jurisdiction, someone will challenge it. I know, as Surendra pointed out, people generally don't go to the courts, but there will be some who will go to the courts, causing unnecessary unrest. So perhaps the word technical could be substituted or replaced with the word jurisdictional. But otherwise the sentiment is correct. In no way is the preeminent position of Islam. The head of the state is the head of the religion of Islam. So the head of state and the head of religion is the same. Muslim education is permitted. Taxpayers' money is allowed to be used for promoting Muslim education. And actually in so many other ways, as I said earlier, 25 to 28 times Islam is honored in the Constitution.
Yes. Now, because you've now suggested, based both on your feedback, your responses just now, that it is a jurisdictional issue rather than technical. Perhaps, the wording could be better. So on that, I wanted to touch on the notion of ultra vires. Vires. I know that there are various ways to pronounce this word. Right, so it's a common legal term. I'm sure you're both very well versed, meaning beyond the powers. So in this case, because you're saying it's jurisdictional, how does it apply exactly when enacting local state laws pertaining to the provisioning of constitutional laws that supersede it?
Prof, you understand?
Perhaps I didn't fully understand your question, but basically the doctrine of ultra vires is a very rich doctrine in administrative law and constitutional law. It means that you may be lacking in jurisdiction. In other words, you don't have the power at all.
Okay.
Or you had the power, but you exceeded it. Or you had the power, but you abused it. Or you had the power, but you did not follow the procedure. So Lord Diplock called it illegality, irrationality, procedural impropriety. And with all due credit to the present federal court, our present Chief Justice has clarified and said, in addition to these three categories, illegality, irrationality, procedural impropriety, there is also constitutional ultra vires. So you are violating the Constitution, not just a statute. You see, the main difference between us and England is this. In England, if I'm a public officer and I'm acting under a statute, I'm within the statute, my action is valid. It cannot be challenged. In Malaysia, there is an additional dimension. The statute itself must be in accordance with the Constitution. I may be following the statute, but if the statute is not following the Constitution, my action is illegal. So I think the doctrine of ultra vires is, in the context of Malaysia, it has more dimensions than in England. The statute cannot be against the constitutional division of federal state powers. And then, of course, the action of the officers should not be contrary to the statute. There are many conversion cases where, for example, the requirements in the state enactment about how a conversion is to take place were not followed.
Right.
For example, in some cases, in some statutes it says minors cannot be converted. In other statutes it says, in other enactments it says, the person who is being converted must be present. He must recite the Shahada, Kalima.
Right.
Now, sometimes these officers register the conversion without these requirements being followed.
Okay.
So, in that case, they are not following the enactment. But as I mentioned earlier, there is an additional dimension of ultra vires, and that is that sometimes the enactment is not following the Constitution.
Yeah.
You
I
mentioned, please.
Yeah. So when we talk about laws in that sense, the ultra vires can come in two scenarios. One is like in Nick Allen's case where they didn't have the power to make the law, and that applies to Parliament and the state assemblies. Or the second scenario, they had the power but they violated some other constitutional provision. So like that famous Negeri Sembilan cross-dressing case, for example, that's an example of the second scenario where the state had the power but it violated certain fundamental rights.
Because you brought that up, cross-dressing. I just wanted to ask you, under the federal list, cross-dressing isn't a crime, right? It's not an offense.
No.
But under Islamic Sharia laws, it is. So I know it's not part of the constitutional challenge brought forward by Nick and her daughter, but could you address this, please? Perhaps, there will be spillover, obviously, from this landmark ruling.
Yeah. So I'm not sorry.
Yeah. So how would this affect, do you think, something like that, like cross-dressing?
I'm not an Islamic law expert, but okay, so let's assume cross-dressing is a violation of the precepts of Islam.
Right.
And therefore, it's within the competency of the state assembly to make that Islamic offense a criminal law. So now we are done with the first category, the competency part. It is a competent law. So a Nick Allen type challenge won't work because it is within the competency. But like what Prof said, any law in Malaysia, any statute in Malaysia, may it be a state law, federal law, a subsidiary law, any order, any regulation, any rule, must conform with fundamental liberties in the Constitution. So we have about 8 to 9 fundamental rights from Article 5 to 13, and perhaps some other provisions arguably. So even though the law was validly made within competence, the second stage is that it must still comply with these human rights or fundamental liberties. So that cross-dressing law, for example, within competence, validly made, but does it then violate my right to life, which includes my right to self-autonomy? Does it violate my freedom of expression, my right to express myself the way I want, to wear clothes the way I want, because that's part and parcel of my freedom to express myself? So in that case, what happened was the Court of Appeal found that cross-dressing provision violated certain fundamental rights, the rights that I mentioned earlier. But when it went to the federal court allowed the appeal on this is what I call a technical ground because the mode of challenge was apparently wrong. So the federal court said that you should have straight come to the federal court under a certain procedure like Nick Allen did, and you should not have filed this in the High Court under a judicial review provision. So because you used the wrong procedure, therefore your challenge was bad. So the federal court allowed the appeal on a technical ground.
I see.
Yep.
I think that
in
gives
that
us
case,
more.
several fundamental rights were invoked. First of all was Article 5, liberty. Then the concept of life. Life includes livelihood. Then there was the issue of Article 8, equality. Girls who dressed like boys were not being prosecuted in the law. But boys who dressed like girls were being prosecuted. Now, I'm not justifying either. What I'm saying is, if cross-dressing is an offense, it must work both ways. You cannot just single out boys, but leave out girls. And that was one of the arguments. And Justice Hishamuddin said, Article 8, equality, gender equality is being violated, along with Article 5, life, Article 5, liberty, and also freedom of expression, Article 10. How you express yourself.
Right. So equality is properly enshrined in the Constitution.
It is.
Right?
And it has grown stronger. In 2001, I think, gender equality was added to Article 8.
Okay.
Previous to that, in 57, 63, there was no gender equality. It was added on at the turn of the century in Article 8, Clause 2.
Okay. So apart from obviously the discrepancies that we're seeing, between Islamic jurisprudence and federal the laws under the federal list, I think it's time probably to address uniformity now, to streamline these criminal enactments, right? So just on Monday, following the ruling, IKIM, or the Institute of Islamic Understanding Malaysia, said it will address the misinformation, like what we've just discussed, basically, we've covered that, surrounding the federal court's judgment on Nick Ellen's successful constitutional challenge. They're launching an initiative to give more accurate facts related to the ruling. Will this clear the air, do you think? It's high time, I guess, for an initiative like this to happen. Yes?
Yeah, I think that's a very good effort. And whilst I think, again, Prof highlighted earlier that precepts of Islam is stateless, so each state will make their respective laws and they're entitled to make those laws. But one must understand that these laws are territorial in nature. So if you're a Muslim who's a resident in Selangor, for example, but you travel to Kelantan, once you're in Kelantan, you are subject to these laws. Then you move to Negeri Sembilan, you are subject to the laws in Negeri Sembilan, and so forth and so on. So having Islamic laws or Islamic criminal laws that are not uniform, who are far apart in different states, is going to cause a lot of confusion to Muslims. Because every time you cross borders, you're subject to different sets of laws, which is why harmonizing these laws throughout the federation is actually a very good idea, but it needs the buy-in from all states. You need all states to come together and agree to have uniform laws. And I think Prof did mention this earlier. What's important is that while the state makes the offense, it is Parliament that gives the punishment. So in Malaysia, what Parliament has done, it's given a blanket approval. This is the maximum, 356. You make the offense, as long as the punishment is within the 356 limit, it's fine. But what I think was actually intended is for Parliament to supervise all these offences. So, okay, for this offence, this is the punishment. This offence, this is the punishment. And that's what we say, or what the federal court has said, is we have a strong federalist system. So yes, we are federal state, but power was meant to be tilted more towards federal, especially when it comes to criminal law.
Prof. Shad?
I think the Nick Ellen case highlights this fact that in some respects, the federal government abdicated its responsibility. Why do I say that? In Schedule 9, List 2, which is, List 2 is the state list, paragraph 1, it says, the jurisdiction of the Sharia court shall be as provided by federal law. Now, to me, jurisdiction refers to three things, at least three things. Number one, who can you try? Number two, what can you try? And number three, what punishment you can administer. Now, as to who you can try, the Constitution is very clear. Sharia courts can try only Muslims. So that issue is not an issue at all. But then, what can you try? The federal parliament had the power to lay down the offences which could be tried by the Sharia courts. It did not do so. The result is that the states now are filling the vacuum. Everywhere it works like that. Whenever there is a vacuum, someone will come in to fill it. And as Surendra pointed out correctly, there are 14 separate Sharia laws on criminal matters, 13 states plus Wilayah. Different states are providing different crimes, different punishments. So I blame the federal government for this state of affairs. If it had in 1965 done its job more thoroughly by defining the offences which the states are allowed to punish. Because the word jurisdiction to me implies not only the power to impose the punishment 365, but also the penalties. In addition to that, so I think my first recommendation would be no need to amend the Constitution. Amend the Sharia Courts Criminal Jurisdiction Act. A second proposal could be this, that Article 76, Clause A, 76A, permits Parliament to delegate some of its, delegate is not the right word. Article 76A permits Parliament to extend the legislative powers of the states into the federal list. So the topic is in the federal list. Federal Parliament can, under 76A, allow the state to pass a law on that topic, subject to some conditions. So the example you were giving about lotteries, betting, gambling, there's a clear problem there. Betting is in the federal list, but licensing is in the state list. Also, there is another law, about horse racing.
Oh, okay.
Horse racing. Horse racing is evidently allowed for everyone. And many Muslims are pointing out, but look, horse racing is also part of gambling, part of betting, and Muslims are not allowed. So I think in some of these areas where Muslims are to be allowed, Muslims are to be forbidden from a particular act because it is an offense against the precepts of Islam, I think the federal government can delegate some of its powers to the states under Article 76A. Then Surendra pointed out the need for uniformity of laws. Actually, under Article 76, that's possible. But as you correctly pointed out, the states' agreement is needed. Actually, in the 80s, the federal government did invite the states. They sent a model Sharia law to the states to say, would you consider it? Not a single state agreed to it. Because the states feel that having power over the Sharia is not only religiously, but also politically a very, very significant factor. So not a single state followed the template that was afforded to them. But I think that would be ultimately a good solution to any of these three. Either Sharia Criminal Jurisdiction Act is amended, uniformity under Article 76, or under Article 76A, Parliament extends the legislative power of the states in those areas where non-Muslims are allowed to commit the act, but Muslims are not because
it's a sin
of the precepts of Islam. Thank you.
Do you think then perhaps, as far as I can recall really, so far today, there was a statement put out by the Sultan of Selangor, Sultan Sharafuddin Idris Shah Al-Hajj, concerning this issue, concerning the ruling. And I'll read out to you in Bahasa Melayu the statement. Semua pihak harus menghormati keputusan Mahkamah Persekutuan dan kedudukan Perlembagaan Persekutuan sebagai undang-undang utama negara perlu sentiasa didokongi oleh rakyat Malaysia. Di dalam menangani isu yang berbangkit ini, apa yang lebih penting ialah usaha kita dalam mencari jalan untuk mengatasi segala permasalahan yang timbul dengan mengkaji kaedah memperluaskan kompetensi Badan Perundangan Negeri untuk menggubal Undang-Undang Jenayah Syariah dalam kerangka yang ditetapkan oleh Perlembagaan Persekutuan. And I believe he also included that some of these efforts should include amendments. He included amendments to the Federal Constitution, Perlembagaan Persekutuan atau Undang-Undang Persekutuan yang berkaitan bagi memastikan kuasa Badan Perundangan Negeri untuk mengubah Undang-Undang Jenayah Syariah termaktub secara jelas dalam Perlembagaan Persekutuan tanpa sebarang kekaburan ambiguity. So, do you think that since you're suggesting that states should actually take up that template, right, that was offered to them some decades ago, do you think that's more along the lines of this? I mean, that would be better than the federal amendments, federal constitution amendments.
Tunku's reminder to all of us to respect the judicial decision, I think is very commendable indeed. Those who take part in democratic systems have a duty to obey first and complain afterwards if we disagree with something. So we cannot say, well, we believe in the Constitution, but this part of the Constitution we don't believe in. I think that's not possible. I think we should show respect to the Constitution till it is amended, if amendment is necessary. But on a personal level, as I said earlier, I don't believe a constitutional amendment is needed. I think there are other ways. Constitutional amendment will require a 2/3 majority.
Yes.
It will also involve the consent of the states of Sabah Sarawak.
Right.
And I think that's a little bit touchy in these present circumstances. May be better to work on the Sharia Court's Criminal Jurisdiction Act. May be better to amend the state assembly laws
Right.
which had trespassed. Now let this be clear. The Sharia state enactments were trespassing on federal jurisdiction.
Right.
There is no question about that. There's a federal court decision, and actually anybody familiar with the Constitution will say clearly they were violating it. So I would think it would not be advisable to say, oh, they were violating, but now we will legalize their illegality. I don't think that's a right way of doing things. I think their illegality must be rectified by removing those provisions
Right.
that were ultra vires their powers.
Right. So Nick Ellen's challenge is a step forward, right?
It is.
This is definitely paving the way forward for constitutional challenges to come, and not just on Sharia laws, but any state laws, right?
Yep. So I think in the past we have had federal laws that were declared incompetent, and such challenges have been mounted. But I think specifically on Sharia laws, I think again you have to remember that Nick Ellen followed the earlier decision of EP22. That was really the case that started it all, although it was only concerned with one provision on sodomy in the Selangor criminal enactment.
Right.
So Nick Ellen's case merely followed the principles which were already decided in that particular case. From the beginning, she was fully aware of the possibilities, of what might come back to her. And nevertheless, she did what she had to do because she believed that it was the right thing to do.
Right.
So I guess in that sense, it was a principled move. And I guess perhaps none of us could have foreseen the extent to which things turned out to be, although we had a rough idea. But throughout the process, because we had to get leave first. We got leave in September 2022. And then you had to file the petition. So it was quite a long process. Throughout the process, she held the ground. She and her daughter, Yasmin, I think she also has to be credited as well.
Yeah.
Both of them held their ground. And even though the tax came in earlier, they never once wavered or said, look, we can't take this. Let's just pull out. No, I think they stood their ground, and until today, they still stand their ground.
And
I think in constitutional law matters, where there is a perceived violation of our basic charter, I think citizens should be encouraged rather than discouraged to go to the courts to seek judicial review. I believe that as responsible citizens, it is our job to uphold our Constitution. And I believe that the rules of locus standi should be relaxed as they were in this case. I also believe that democracy is not simply voting once every 5 years. I think democracy requires of all of us a continuous journey, a continuous struggle to uphold the principles of the law, especially of our Constitution. So I'm very much in favor of looking at the issue in a broader way, and that is this, that citizens must be encouraged to provide accountability to the government of the day by raising questions. And I just want to mention this to you. In some countries, there are provisions permitting greater involvement of the citizens in the lawmaking process.
Right.
For example, in many countries, there is the procedure of referendum. A law is passed, an amendment is passed, but it is sent to the Rakyat for their vote of approval or disapproval, referendum. There are provisions in some countries called initiative, where citizens can get together and say, we want the assembly to consider passing this law, initiative. There are provisions in some countries of recall. Citizens will file a petition to the assembly and say, recall this law. So I think we must look at the issue from the point of view of allowing democracy to percolate from the top level to the bottom level. Democracy should be bottoms up, not top down. At the moment, it's all top down.
Right.
So I'm delighted that actually these two citizens who also happen to be lawyers took up this case and stood firm,
Right.
and the court decided in their favor.
Right.
I hope there'll be more such citizens coming
Right.
out and taking the risk, but standing firm for their ideals.
Right. I mean, the fact that they've received death threats, that's quite alarming, really, when, as you pointed out, they're merely just carrying out their duty as
Yes,
officers
it
of the law and also as sensible citizens
Yes, indeed.
who uphold the Constitution. Yeah?
Yeah.
More Nikolains, more Surens, more.
Yeah, I mean, my past experience dealing with this sort of constitutional cases, usually the litigant normally gets prosecuted under the law, or they get charged, or they are somehow the law is implemented on them, and then they mount a legal challenge. But it's even worse there because there's a spotlight on you immediately, judgments being cast against you.
Right.
Oh, this person got prosecuted and he's doing this to try and escape liability from the law, so he's
Right.
now challenging the validity of the law. Like the cross-dressing case, for example, there were threats. The threats were attempted to be carried out, and a lot of things happened there. So which is why it's very important for these sort of constitutional challenges to open the door to allow others to challenge, because people who might be directly affected by the law might not have the means, the privileges to become or challenge the law in court, because it's not an easy thing to do, and a lot of people don't want that kind of spotlight. So then the whole thing is just left unaddressed, which is why I thought it was very good and it was very important for the majority of the federal court to open that door wider. So if the marginalized communities can't do it, and often these are the communities that are affected,
Right.
then it is then up to lawyers or other people in the community to bring a challenge on their behalf, and then they should be allowed to do so.
Great.
Yep.
Prof. Shad, anything before we end?
Well, this is a journey, not a destination. I think there are more such issues that need to be raised.
All right. So moving forwards, we'll hope to see more
Yes,
of
hopefully.
this. Yeah. Thank you so much again,
Thank you.
Professor Shad and Surendra,
Yeah,
for
thanks.
coming on. Really appreciate, and it's great to have you on our couch here today, where we get a chance finally to really go into the crux of this issue, the ruling that was delivered last Friday. That's it for now. And for those of you who've stayed with us watching this episode, thank you so much for tuning in. If you like this episode, please hit that like button and subscribe to our YouTube channel at NSD Online. We're also on the social media platforms. We're on Instagram, Facebook, and Twitter, or X, at NSD Online. So that's it from me. Has been Hassan. Till next time. Goodbye.